there, curious minds. Welcome back to the deep dive. This is where we take those really complex topics, strip away all the jargon, and hopefully get straight to those aha moments you're looking for. Today, we're diving headfirst into a legal concept that, well, at first glance might seem like a bit of a mouthful, the plurality of crimes.
Right.
Yeah, imagine a scenario, right, where maybe just one single action or perhaps a whole series of actions leads to multiple legal consequences. How does the law even begin to untangle that kind of knot? That's really our mission today. We've got a fascinating stack of legal excerpts, some case law distinctions, all aimed at giving you a shortcut, really, to understanding this critical area of criminal law. So whether you're prepping for a meeting, just trying to stay sharp, or maybe you're just insanely curious about how justice works, get ready. We're going to explore how legal systems classify and penalize situations where one individual commits more than one offense. Okay, let's unpack this. First things first, then. What exactly is plurality of crimes? What are we actually talking about here?
Well, at its most fundamental level, plurality of crimes just refers to the situation where an individual commits multiple crimes. Pretty straightforward on the surface. But what's really fascinating here for you is how these crimes can actually manifest. It's not always obvious. These multiple crimes, they might stem from just a single isolated act. Think of it like dropping a single stone into a pond. It creates lots of ripples, right? Affecting different things all at once. Or they could come from a whole series of acts, but they're all driven by a single criminal intent, like a chain reaction maybe with just one initial push. Alternatively, they might be completely different, unconnected acts, each one having its own distinct origin, like setting off multiple fireworks, one after the other, each a separate decision.
Ah, okay. That's actually a great way to visualize it. The stone, the chain, the fireworks. So it's not just about did someone break one law or many, but more like how did they break those laws and what was their underlying intent? That seems key. And from what our sources tell us, there are two main types or categories of plurality. Formal, which is sometimes called ideal plurality, and material or real plurality. Let's start with formal plurality. What's that about? Formal plurality. It sounds, well, formal, but our sources break it down really nicely. This apparently arises when a single act gives rise to two or more grave or less grave felonies, so serious stuff. And this concept, we learn, aligns directly with Article 48 of the Revised Penal Code, which governs what we call complex crimes.
Exactly. The core idea here is that the perpetrator executes just one action. But that singular action has multiple prohibited outcomes, multiple negative consequences, legally speaking. It's not about two separate decisions, I'll do this bad thing, they'll do that bad thing. No, it's one decision, one action, leading to a kind of cascade of legal infractions. It really revolves around the idea of a single physical act leading to multiple distinct offenses.
Okay, so if it's a single act, does that mean there's also like a unified criminal intent behind it, one goal?
Precisely. That's the crux of formal plurality. It involves a unified criminal impulse. The individual isn't sitting there thinking, okay, first I'll commit crime A, and then step two, I'll commit crime B. Rather, they have one overarching criminal purpose, and that one impulse, that single drive, leads to the commission of multiple offenses. So these crimes aren't isolated incidents, they're interconnected. They all stem from that single criminal purpose.
Right, right. And here's where it gets really interesting, especially for the penalties. The sources highlight single penalty as a defining characteristic. What does that mean?
Indeed. So despite the multiplicity of offenses, despite maybe several laws being broken technically, the law imposes just a single penalty. And this penalty corresponds to the most serious crime committed. And importantly, it's applied in its maximum period, its highest range. Now, this raises an important question, right? Why only a single penalty? Well, it reflects that unified intent we talked about. The legal system recognizes there was one primary driving force, one core decision, and it penalizes the gravest outcome of that single action, not every single ripple.
Got it. Okay, let's look at some examples from our sources. That always helps make things concrete for, for you listening. Consider someone throwing a hand grenade, like we mentioned. It results in multiple deaths, multiple injuries. That's a single act, throwing the grenade. But it leads to several grave felonies, murder, multiple attempted murders. How does formal plurality apply there?
In that scenario, that single act, the throwing of the grenade, that's the root cause for all the subsequent suffering and death. Because it's one action driven by one criminal impulse, it constitutes a formal plurality. So the perpetrator faces a single penalty, and that penalty corresponds to the most serious crime, which would likely be murder in this case, imposed in its maximum period. The law essentially sees it as one catastrophic event with multiple victims rather than, say, 10 separate criminal acts just because 10 people were hurt.
Okay, that makes sense. What about something less explosive, like a complex assault that results in both serious and less serious physical injuries?
Yeah, that's another classic example of what's called a compound crime under Article 48. If a single act, say one punch or maybe a kick, results in both serious physical injuries and less serious physical injuries on the victim, that's it. Both are considered grave felonies, legally speaking, and they both stem from that one physical act, that single punch. So the penalty for the more serious crime, which would be the serious physical injuries, would be imposed in its maximum period. The legal system doesn't sort of bifurcate the assault into two separate acts just because the resulting injuries have different legal classifications. It was one blow.
Or what if a single act of pressing the trigger of a firearm results in the deaths of multiple victims, like one bullet goes through someone and hits another?
Again, it's a single physical act pulling the trigger, but with multiple tragic outcomes. Even though several people are killed, the act is understood as being driven by a single criminal impulse at that moment. So it's a case of formal plurality, a compound crime. And the penalty for murder, the most serious outcome, would be applied in its maximum period. The legal focus is on that singular destructive choice.
Hmm. What if a robbery is committed and in the course of it, a homicide occurs, but maybe accidentally? Does that change things?
That's a really interesting point. It's still considered a complex crime of robbery with homicide. The single overarching event was the robbery committed through violence or intimidation. And that act led to both the taking of property, the robbery, and the death, the homicide, even if the killing itself wasn't the primary intention. The key is that the intent to rob was present, and the death occurred on the occasion of or by reason of that robbery. It's linked. So, yes, the penalty for the special complex crime of robbery with homicide would be imposed as a single combined offense.
Wow. Okay. And one more. What about illegal possession of a firearm that's then used to commit homicide? Are those treated as separate or?
Ah, now this one can be a bit more debated, according to our sources. But one perspective indicates that if the firearm is actually used to commit the homicide, then the illegal possession can be considered a necessary means for committing the homicide. If that's the view taken, it makes it a complex crime. The logic there is that the possession wasn't just a coincidence. It was integral. It was essential to carrying out the more serious crime of homicide. In such a scenario, the penalty for homicide would be imposed in its maximum period, effectively encompassing the means, the illegal possession by which it was committed. Though, as we might touch on later, there can be nuances depending on specific laws.
Okay, so formal plurality is clear. One act, one impulse, multiple outcomes, and generally one penalty for the most serious part.
Okay.
So then, what does this all mean for the opposite concept, material or real plurality? How does that work?
Right. Material plurality is essentially the mirror image. It's the complete opposite. It refers to situations where the accused commits two or more crimes, and critically, this is the key difference. Each crime is driven by a distinct criminal intent. A separate decision, a separate goal each time. Think of that chef analogy again. But instead of one dish with many components, it's like making a multi-course meal. Each dish appetizer, main, dessert, is intentionally different, requiring separate planning and execution. In material plurality, each crime is treated as a separate offense, and crucially, each carries its own corresponding penalty.
Ah, okay. So no merging or absorbing of penalties here, like they don't get combined.
That's absolutely right. No merging, no absorption. In material plurality, each crime is evaluated independently by the court. The penalties are not absorbed or combined because each act is viewed as a fresh decision, stemming from a new, independent motivation or criminal purpose. The punishment reflects the gravity of each separate offense. It acknowledges that the perpetrator had multiple distinct criminal purposes. So, unlike formal plurality's unitary criminal impulse, material plurality involves multiple and distinct criminal impulses. The crimes aren't necessarily linked by a single overarching purpose. They represent independent acts with independent motivations. Consequently, the defining characteristic here is the imposition of separate liability, separate punishment for each crime committed. Each offense stands alone because it came from its own distinct criminal intent.
Okay, let's dive into some examples of material plurality then. These should really highlight that difference in intent you're talking about. What about an individual killing two victims, but with different shots, maybe at different times, specifically to conceal a separate crime like malversation? How is that material plurality?
Yeah, in that kind of case, the sources emphasize that each killing is driven by a separate intent. Perhaps the first killing was for one reason, maybe connected to the initial crime itself, but the second killing, that was specifically to conceal the malversation, to silence a witness, perhaps. These are viewed as two distinct decisions to kill, each with its own separate criminal purpose. They aren't just two outcomes of one single act. Therefore, they are treated as separate offenses, likely 2 counts of murder, each carrying its own penalty.
Okay. Or, slightly different, an individual commits malversation, let's say, misappropriating public funds, and then subsequently, maybe days or weeks later, kills someone specifically to conceal that initial crime.
That's a very clear case of material plurality. The act of killing is motivated by a completely separate criminal intent, the intent to obstruct justice, to evade accountability for the malversation. That intent is entirely distinct from the initial intent to misappropriate the funds. They are 2 separate criminal chapters. So the penalties for both the malversation and the murder would be applied separately, reflecting those 2 distinct criminal choices made at different times with different immediate goals.
What about if someone commits robbery and then later, maybe after the robbery itself is technically over, they detain the victims to demand additional ransom money?
Again, you see that crucial shift in intent. The initial robbery, the taking of property by force or intimidation, might have concluded. The initial goal achieved. The decision to then detain the victims, maybe hold them somewhere else, specifically to get more money, that reveals a new criminal purpose. That purpose is extortion or kidnapping for ransom. So the perpetrator would be held liable for both the initial robbery and the subsequent detention extortion, as they are separate acts driven by distinct criminal intents, even if they happen close together chronologically.
And one last one on this. Homicide followed by arson to conceal the crime, like burning down the house after the killing.
Yes, similar logic applies. Once the homicide is committed, the act of setting fire to the crime scene to destroy evidence is a new, distinct act. It's driven by a separate intent, the intent to obstruct justice, to evade punishment for the homicide. This intent is separate from the initial intent to kill. Therefore, the perpetrator would face separate penalties for both the homicide and the arson. 2 distinct bad acts, 2 distinct intents, 2 penalties.
Okay, that's a lot to keep track of, but that difference in intent really does seem paramount. It's the core distinction. Our sources even give us a handy summary table, which is helpful. So for you listening, here's a quick recap of those key differences between formal and material plurality. First, when we talk about the nature of the act, formal is usually a single act resulting in multiple serious felonies. Material involves multiple distinct acts, each typically with its own intent.
Exactly. And then for criminal intent, formal has that unitary criminal impulse driving multiple offenses from one decision point. Material, in contrast, features multiple distinct criminal intents, one for each separate act.
And finally, the bottom line, the penalty. In formal plurality, it's generally a single penalty pegged to the most serious crime, often in its maximum period. Whereas in material plurality, it's separate liabilities and separate penalties for each crime. That really clarifies things. It really does seem to boil down to whether the criminal mind had one big overarching plan with multiple, perhaps unforeseen, consequences stemming from one act. Or if they had several distinct, separate, nefarious designs, each put into action independently.
That's a perfect way to put it. One plan, many results versus many plans, many results.
Okay. Now let's unpack another really crucial principle in this legal landscape, the doctrine of absorption. It's sometimes called the single criminal impulse rule. What's this about?
Right, this is a really fundamental principle in criminal law. It's basically designed to prevent an offender from being punished multiple times, unfairly, for offenses that were all committed under a single criminal intent. So it's really a cornerstone of fairness and proportionality in sentencing. And it's actually codified, written into the law in Article 48 of the Revised Penal Code that we mentioned earlier. At its core, the doctrine of absorption recognizes that while, yes, technically a single act or a closely related series of acts might violate multiple provisions of the law, the offender's criminal intent, their underlying purpose, is the true driving force that the law should focus on. So instead of just piling on separate penalties for every technical violation, the law focuses on that overarching criminal purpose. It punishes the graver offense, the main goal, and the lesser offenses, the ones that were essentially just part of the same criminal scheme or necessary steps, are considered absorbed into the main one. They don't get separate punishments.
Ah, okay. So it prevents the state from kind of unjustly multiplying penalties, making sure the punishment fits the overall culpability, the overall badness of the plan, rather than just a technical tally of how many laws were broken along the way.
Exactly. You put it well. It's like pouring multiple small streams into one large river. Legally, we're measuring the flow and impact of the main river, not counting every single stream that fed into it. It aims to ensure the penalty is commensurate with the offender's actual culpability and prevents excessive, disproportionate punishment that might arise from rigidly applying penalties for every single offense committed as part of one single criminal impulse.
Let's see the doctrine in action then. We need examples. Our sources describe an accused person who is motivated by a single impulse to steal. Let's say they go into a yard and grab 5 roosters, but these roosters happen to belong to 5 different owners who live nearby. What's the outcome here using absorption?
Right. So despite there being 5 different victims, 5 different owners who suffered a loss, the accused is generally only liable for one count of theft under this doctrine. Why? Because the criminal impulse, the intent to steal, was singular and the same. It didn't matter to the thief's intent that the ownership was divided. The act of taking several roosters from different owners, but at the same time and place, is seen as constituting a single unified criminal act in the eyes of the doctrine of absorption. It's driven by that one intent to steal things from that location at that moment.
But wait, you mentioned earlier that if someone presses the trigger of an automatic rifle and that single action fires many bullets hitting many victims, they are liable for each death separately. How does that fit with absorption? That sounds like one act too.
Ah, yes. This is a critical distinction, and it really highlights the nuances here. It shows where the single impulse idea gets complicated. While the physical act of pressing the trigger might be singular, the law, in that specific context, often treats each bullet fired that hits and kills a victim as representing a separate act driven by its own criminal impulse to kill. So, in that specific, highly dangerous scenario with an automatic weapon, the accused is typically held liable for as many homicides or murders as there are victims. The reasoning, though debated, often revolves around the idea that even with one trigger pull, the sheer volume of lethal force unleashed implies as many criminal impulses to kill as there are persons killed. Each death is seen as a distinct, albeit incredibly rapid manifestation of lethal intent, not merely an accidental ripple effect. It's treated differently than, say, the grenade scenario.
Wow, okay. That's a fascinating twist. So it's not just the physical mechanics of the act, but sometimes the perceived intent behind the nature and consequences of that act that matters for absorption? What if someone kidnaps a person specifically to extort money? Kidnapping for ransom.
In that case, the accused is liable for the specific crime of kidnapping for ransom. Even if, maybe during the kidnapping, they also harbored some thoughts or intent to maybe kill the victim later if things went wrong, the principal intent that defines the crime is the intent to deprive the victim of liberty and use that deprivation to extort money. So the act of kidnapping combined with the ransom demand becomes the singular gravest offense, and under the doctrine of absorption, other potential lesser intents or related minor offenses committed during the kidnapping might be absorbed into that primary charge.
It sounds like a powerful doctrine for ensuring fairness, but it must have its limits too, right? It can't apply everywhere.
Absolutely.
Yeah.
It definitely has limits. One key limitation arises when the different offenses involved are punished under different statutes. For example, one crime under the main penal code and another under a separate special law. Absorption may not apply smoothly in such cases, as the offenses might be considered legally distinct simply because they come from different legal sources, different laws passed by the legislature. It's like trying to mix oil and water if the legal frameworks are fundamentally different. And another major limitation, perhaps the most important one, goes back to intent. Independent criminal intent. If the offender clearly exhibits multiple and distinct criminal intents for different acts, even if they're related, the doctrine simply does not apply. Each offense motivated by a separate criminal intent is considered a distinct crime and warrants separate penalties. We saw this clearly with material plurality.
Like our earlier example of robbery followed later by illegal detention for more money.
Precisely. That's a perfect example of where absorption wouldn't apply. If the accused initially commits robbery, maybe takes a wallet, but then subsequently, as a separate decision, detains the victims to demand additional money or information, that illegal detention is a separate crime. It has a distinct criminal intent, extortion, or coercion, separate from the initial intent to rob, which was already completed. The detention is a new, separate criminal decision, so no absorption.
Or what about falsification of documents on separate occasions to conceal an earlier act of malversation?
Same principle. If a public officer, say, misappropriates funds, malversation, and then later, maybe on 2 separate occasions, falsifies different vouchers or receipts to try and cover it up, each act of falsification is typically treated as a separate crime. Each is driven by a distinct intent at that specific moment to create a false record to conceal the prior crime. They are not absorbed because they are distinct acts performed at different times, driven by distinct, albeit related, intents to cover up. The distinct occasions and the new decisions to falsify each time matter.
Okay. And finally, you mentioned special complex crimes earlier. The doctrine doesn't apply there either, you said.
That's correct. Special complex crimes are sort of pre-absorbed by definition. The law itself has already bundled specific combinations of offenses like robbery with homicide into a single indivisible offense with a specific singular penalty prescribed by law. So the absorption doctrine isn't needed because the law has already done the work of defining it as one integrated crime. You can't absorb something into itself.
Right, right. Okay. We've touched on complex crimes a few times now, specifically under formal plurality in Article 48, but our sources dedicate a whole section to really getting into the weeds here. So let's zoom in. What exactly defines a complex crime again, and what are its types?
Okay, good idea. So complex crimes under Article 48 are instances where a single act constitutes two or more grave or less grave felonies. That's the core. One action, multiple serious crimes resulting directly from it. Crucially, even though it involves multiple offenses legally, a complex crime is still treated as a single crime for punishment purposes. It stems from one criminal intent. And the penalty, as we've discussed, is for the most serious offense involved, and it's imposed in its maximum period.
And our sources tell us there are two main forms or types of complex crimes, compound crime and complex crime proper. Can you break those down for us?
Let's do it. First, compound crime. This arises when a single act itself, just the physical action, directly results in two or more grave or less grave felonies. A key aspect here is that the single act is the only means or the direct cause of committing the other offenses. Think of it like hitting one button that simultaneously activates multiple dangerous mechanisms.
Like our multiple deaths from a grenade explosion example.
Yes, exactly. When that single act of throwing the hand grenade results in the death of multiple people, this is a classic compound crime. It involves multiple counts of murder, technically, but they all stem directly and solely from that singular act of throwing. Or, as we said, if a single punch or kick results in both serious and less serious physical injuries, that's also compound crime. The single act constitutes two grave felonies directly.
And multiple deaths from a single gunshot if the bullet passes through one victim and hits another, you mentioned that too.
That's another perfect example of a compound crime. The single act of firing the gun caused multiple instances of homicide. So the shooter would typically be liable for multiple counts of murder, but punished under the compound crime doctrine as one complex crime, with the penalty for murder in its maximum period. Similarly, think about multiple casualties from a reckless driving incident. Maybe one act of dangerously swerving results in both a death and serious physical injuries to others. That's a compound crime, because the single negligent act caused multiple offenses.
So, boiling it down, the key elements of compound crime are 1. A single act, 2. Resulting in multiple grave or less grave felonies, and 3. Driven by a single criminal intent.
Precisely. And that single act can be a single physical movement, like throwing the grenade, or maybe a series of actions performed so closely in time they are considered a single functional unit, like firing one shot. It must result in at least two felonies, which can be the same type, like multiple murders, or different types, like homicide and physical injuries. And critically, there's only one criminal intent driving that single act, even if it produces multiple offenses. This single intent distinguishes compound crimes from material plurality, where you have separate intents leading to separate liabilities.
Okay, that's compound crime. What about the other type, complex crime proper?
Right. Complex crime proper. This is a bit different. This is where a single act still constitutes two crimes, but one offense is a necessary means for committing the other. It's a slightly different relationship than a compound crime where the act itself causes both. Here, one crime enables the other.
So, the first crime is like a stepping stone, a required tool for achieving the second crime. Like the example often given, falsification to commit estafa.
That's the absolute classic example. Estafa is essentially fraud or swindling. So the act of falsifying a document, like forging a signature or changing numbers, isn't just a separate crime floating on its own. It's essential for carrying out the estafa. The falsification creates the means by which the offender deceives the victim and gains an unlawful financial advantage. The fraud wouldn't work without the fake document. And our sources emphasize that the falsification must be a necessary step for that specific instance of fraud. Simply falsifying a document randomly, without the immediate intent to use it to commit estafa right then, wouldn't necessarily make it a complex crime proper. The linkage is key.
You mentioned a fascinating case earlier from our sources, U.S. v. Hernandez. It involved using a fictitious marriage to commit seduction. How did that work as a complex crime proper?
Indeed, that's a really illustrative, albeit old case. The accused pretended to be a priest, which is a crime itself, usurpation of official functions, and staged a fake marriage ceremony, specifically to seduce a 15-year-old girl under false pretenses. The court found that the usurpation of official functions, the act of pretending to be a priest, was the necessary means used to carry out the seduction. Without that specific pretense, that specific lie enabled by the first crime, the seduction might not have been successful. It highlights that the necessary means doesn't always have to be another formal felony, but an act essential to accomplishing the principal offense.
Now, there seems to be a point of debate or maybe conflicting perspectives when it comes to illegal possession of firearm used to commit homicide being a complex crime proper. You touched on this.
Yes, this does raise an important question and shows how law can evolve or have different interpretations. One significant case, People v. Erdeta, stated that this does not constitute a complex crime proper. The reasoning was primarily that the two offenses, homicide and illegal possession, are punished under different statutes. Homicide under the Revised Penal Code, illegal possession often under a separate special law. This difference in legal source was seen as a barrier. However, a different viewpoint exists, suggesting that because the illegal possession is, in fact, often a necessary means to commit the homicide, you need the gun to shoot someone, logically, a complex crime proper could exist. This really shows the legal system grappling with the interplay between intent, the necessary means concept, and the structure of different laws, the penal code versus special laws. It's not always black and white.
So, about that specific phrase, necessary means, does it mean absolutely indispensable, like there was literally no other way to commit the main crime?
That's a great clarifying question, and our sources are clear. Necessary means does not necessarily equate to indispensable means. A crime can still be a complex crime proper, even if the secondary offense, the means, wasn't absolutely the only theoretical way to commit the principal one. For instance, in that falsification to commit estafa example, maybe the offender could have theoretically committed the estafa through some other elaborate lie or trick. However, if falsification was the chosen method, the actual path taken, and it was an essential step in the execution of that specific fraud, then it constitutes a complex crime proper. The key factor is whether the secondary offense was integral to the accomplishment of the primary offense in that specific instance, even if other theoretical avenues might have existed. Was it the tool used?
And procedurally, for lawyers and courts, this has implications too, right? How it's charged and proven.
Yes, definitely. For charging the offense, the prosecution must properly charge the complex crime, whether compound or proper, in a single information, a single charging document. If they charge the two offenses separately, the accused could potentially raise the issue of double jeopardy later on, arguing they're being tried twice for essentially the same criminal event or impulse. And then for evidence and conviction, even if a complex crime is properly charged, the evidence presented at trial must support both component offenses. If, say, in a falsification to commit estafa case, the prosecution proves the falsification but fails to prove the elements of estafa beyond a reasonable doubt, the accused can only be convicted of the crime that was proven, which would be falsification in that instance, not the complex crime.
Got it. Okay, now we move to yet another category, special complex crimes. Our sources describe these as very specific combinations of offenses that are treated by law as a single indivisible crime with a specific penalty already designated by the law itself. They're sometimes called composite crimes, basically combining multiple serious offenses into one legally unified whole.
Exactly. These are specific crimes that are predefined by the law, usually the Revised Penal Code or amendments to it. They're singled out often due to their inherent severity and the very common, almost expected, linkage between the component acts in certain criminal situations. The RPC outlines several well-known examples, such as rape with homicide, kidnapping and serious illegal detention where the victim is killed, robbery with homicide, attempted or frustrated robbery where a homicide occurs, and certain types of arson that result in homicide.
So, what are the key characteristics that really set these special complex crimes apart from the other categories we've discussed?
The first key characteristic is indivisibility. The individual components of a special complex crime are legally inseparable. They're treated as one single crime. Unlike compound crimes, where one act causes multiple results, or complex crimes proper, where one is a necessary means for another, the components of a special complex crime are inherently linked by the specific wording of the law. They were not treated as separate offenses at all for prosecution and sentencing. The law says, this combination is this one crime. The second characteristic is the specific penalty. Each special complex crime has a very specific, often very harsh penalty prescribed directly by the RPC or the relevant special law. Typically, this penalty corresponds to the maximum possible for the most serious offense involved, sometimes even higher.
Let's look at some powerful examples to really understand this. Robbery with homicide. This occurs when a homicide results by reason of or on the occasion of the robbery. This is a huge one, partly because, as you mentioned earlier, the specific intent to kill isn't necessary, right?
That's absolutely crucial to understand about robbery with homicide. The intent to kill is not a required element for this specific special complex crime to be committed. If someone dies as a result of the violence or intimidation used during the robbery, even if that death was accidental or unintentional, maybe a robber fires a warning shot into the ceiling and a piece of debris falls and kills someone hiding above, or a victim has a heart attack due to the stress, the robber is generally liable for the single indivisible crime of robbery with homicide. The death occurred on the occasion of the robbery, fulfilling the legal criteria for this very serious, special, complex crime. The law essentially says the extreme risk created by the robbery itself leads to this combined liability.
Wow, okay. Kidnapping with homicide also seems to have had an interesting evolution according to our sources.
Indeed. The law surrounding kidnapping with homicide evolved significantly, particularly with a major amendment, RA number 7659. Previously, there might have been some legal distinctions based on whether the murder of the kidnapped victim was intended from the start or if it was more of an afterthought during the detention. The amendment effectively eliminated this distinction. It made kidnapping resulting in homicide a special complex crime regardless of when the intent to kill was formed. So now, if a kidnapped person is killed at any point in the course of their detention, whether the killing was purposely sought from the beginning or just decided upon later, the crime is punished as the single special complex crime of kidnapping with homicide. This really reflects the inherent gravity and danger associated with the act of kidnapping itself. The law recognizes the high risk of death once someone is unlawfully detained.
And rape with homicide, similar logic apply.
Yes, very similar logic to robbery with homicide. This special complex crime does not require a separate intent to kill. If the rape victim dies as a consequence of the sexual assault itself, the offender is liable for the single crime of rape with homicide. Notably, the law also considers infection with a sexually transmissible disease during the rape, if that disease ultimately leads to the victim's death, as a qualifying circumstance that results in liability for rape with homicide. It highlights again how the law bundles these severe, interconnected outcomes into one defined crime.
And destructive arson resulting in death is another example listed.
Yes, certain forms of arson, particularly those defined as destructive arson, which might involve specific locations or means, become a special complex crime if death results. Again, the death and the arson are intrinsically linked by the law into one single severely punished offense.
And just like with regular complex crimes, the procedural aspects are important here too, right? Charging and evidence.
Absolutely. Procedurally, it's critical. For single information, the prosecution must charge a special complex crime in one single information charging document to avoid potential double jeopardy issues. You can't charge robbery and homicide separately if the facts fit robbery with homicide. And for evidence, the prosecution has the burden of presenting evidence that proves all the essential elements of the specific special complex crime as defined by law. If, for example, they prove a robbery occurred, but fail to prove beyond a reasonable doubt that the death occurred by reason of or on the occasion of that robbery, the accused cannot be convicted of the special complex crime of robbery with homicide. They might still be liable just for the robbery, or perhaps for homicide separately if the intent was truly independent, but not the special complex crime itself.
Okay, shifting gears again slightly, let's look at continued crime, which is known as delito continuado in Philippine law, drawing from Spanish legal tradition. This seems to refer to multiple criminal acts, which might look separate on the surface, but are actually considered legally as being driven by a single criminal impulse and therefore constitute just a single crime for penalty purposes.
That's right. This principle, delito continuado, recognizes that even though multiple distinct physical acts are performed, maybe over a period of time, they are all linked by unified purpose and intent. Because of this unified intent, the law warrants treating them as a single offense when it comes to imposing penalties. It prevents unfairly multiplying the punishment for what is essentially one ongoing criminal scheme or impulse. It's like telling a story in several chapters. Even though there are chapter breaks, it's still one single narrative driven by one plot.
So the essential elements of continued crime are key here for identifying it. What are they?
Yes, the sources list three essential elements. One, plurality of acts. There must actually be two or more distinct physical acts performed by the accused. Two, unity of criminal intent. This is crucial. All those distinct acts must be driven by a single, unifying criminal impulse or purpose, one goal behind all the actions. And three, Unity of criminal offense violated. All the acts must violate the same provision of the law or the same type of offense.
Okay, how do we distinguish this delito continuato concept from some of the similar concepts we've already covered, like complex crime?
Good question. The distinctions are important. For complex crime, remember, that's usually a single act constituting two or more felonies, like the grenade or the single punch. Delito continuato, however, involves multiple acts performed over time, but linked by one intent. So, for example, a single trigger press leading to multiple deaths is a complex crime. But someone sending multiple threatening letters over several months to extort money, that's multiple acts driven by one intent, making it delito continuato. It's the many acts from one purpose of delito continuato versus the one act with many immediate outcomes of a complex crime. Then there's continuing crime, which we'll get to in just a moment. While both delito continuato and continuing crime share that element of a single criminal intent, the key difference is that delito continuato involves distinct, separate acts performed over a period, whereas a continuing crime is characterized more by an ongoing, uninterrupted criminal act or state. It's a subtle but important difference.
Let's use some examples for delito continuato to make it clearer. Our sources mention extortion through threatening letters, as seen in a case called People v. Moreno.
Yes, in that specific case, the accused sent a whole series of threatening letters over several months, all demanding money from the victim. The court held this was a continued crime, delito continuato. Why? Because the sending of each letter, while technically a distinct physical act, was clearly driven by the single unifying criminal impulse to extort money. It was one overarching plan executed in stages through multiple letters, so one crime of extortion encompassing all the letters.
And what about the theft of multiple roosters or cows from another case, Santiago v. Garchitorena? We touched on this under absorption too.
Right, that case fits here as well. The accused took 13 cows, which happened to belong to 6 different complainants, but took them all at the same time and from the same place. The court ruled this was a continued crime of theft. The accused was driven by a single intent to steal at that moment, targeting the animals in that location. The fact that the ownership was divided among 6 people didn't create 6 separate intents to steal in the accused's mind. It's one criminal purpose: steal the cattle carried out through multiple immediate takings from the same spot. So one count of theft under delito continuato.
But surely there are exceptions. Situations where multiple acts aren't treated as delito continuato, even if they seem related.
Yes, absolutely. The unity of criminal intent element is strictly applied. If that unity is broken, delito continuato doesn't apply. For example, kidnapping with multiple criminal impulses. If the accused kidnaps someone with the primary intent to extort ransom, but then subsequently during the detention maybe develops a personal grudge and decides to kill the victim for that separate reason, then the initial kidnapping for ransom and the subsequent homicide are considered distinct offenses. The new, independent intent to kill breaks the continuato chain. It's not part of the original plan. Also, think back to our example of separate acts of falsification to conceal malversation. If a public officer commits malversation and then falsifies documents on 2 separate occasions, maybe weeks apart, to conceal previous acts, each act of falsification is generally treated as a separate crime. Each is driven by a distinct intent formed on that separate occasion to cover up the initial crime. The distinct occasions and the fresh decision each time prevent it from being a single continued crime of falsification. And one more: multiple libelous publications. Say a newspaper publishes a defamatory article, but within that one article there are 2 different libelous stories, each targeting different individuals with different accusations. This is generally considered 2 separate acts of libel, each with a distinct criminal intent directed at a different person. The distinct targets and distinct defamatory claims usually make the intent distinct for each, preventing it from being a single delito continuato of libel.
So, to apply this doctrine correctly, courts really need to consider some key considerations. It's not always straightforward.
Absolutely. It requires careful analysis of the facts. While temporal proximity, how close in time the acts occurred, isn't always the deciding factor, it can certainly be relevant. Acts very far apart are less likely to share a single intent. The similarity of modus operandi, how the acts are committed, can also be important. If the method is identical each time, it might suggest a common plan, a single underlying intent. But critically, the most important factor is usually the motivation and objective, digging into the underlying reasons and goals behind each act. That's crucial in determining whether there was truly that unity of criminal intent required for delito continuato.
Okay, that covers continued crime. Finally, let's quickly clarify continuing crime. You mentioned it differs slightly from delito continuato.
Right. A continuing crime involves a continuous unlawful act
or maybe a series of acts that are so interconnected they form one uninterrupted offense. It's spurred by a single impulse, but carried out by what the law calls an unintermittent force. It just keeps going. A good example, as our sources state, is the crime of rebellion. It's not seen as ending until the unlawful activity, the uprising itself, actually ceases. It's an ongoing state of criminality. This ongoing nature also has a very important practical consequence for legal proceedings. The prescription period, the time limit for prosecuting the crime, generally starts only when the crime ends, when the continuous act stops, not way back when the initial act was committed. This is a crucial distinction. So the concept of a continuing crime differs from delito continuado in that delito continuado involves distinct plural acts over a period, like the letters, the thefts. A continuing crime is more like one single unbroken transgression that persists over time. However, they both share that common element of being driven by a single criminal intent. Think of delito continuado as a series of distinct footsteps leading to one destination, while a continuing claim is like drawing a single unbroken line moving forward over time.
Okay, wow. That is a lot of different concepts, distinctions, and rules to keep straight. Formal plurality, material plurality, complex crimes, compound and proper, special complex crimes, absorption, continued crime, continuing crime. For you, our listener, trying to navigate this legal landscape where multiple crimes might be involved, it can seem incredibly complex, almost overwhelming. But thankfully, our sources offer a clear, step-by-step approach, almost like a diagnostic flowchart, to help determine how to classify situations involving multiple crimes. It gives you a structured way to think.
Exactly. It provides a logical sequence to analyze these scenarios. Step 1. Identify the number of acts and criminal intent. This is foundational. Start by determining how many distinct criminal acts were performed. Then, crucially, ascertain whether these acts seem to be driven by a single unified criminal intent or by multiple independent intents. This is your starting point, the compass for the legal journey. Step 2. Distinguish between continued crime, delito continuado, and separate offenses. If you found multiple acts, but potentially a single criminal intent, consider if it fits the delito continuado model. Does it involve several acts driven by one unified purpose, all violating the same law, like stealing multiple roosters from different owners at the same time? However, if you determine there were separate, distinct criminal intents involved for each act, then each act is treated as a separate offense under material plurality, like the kidnapping for ransom, then later deciding to kill for a personal grudge. Separate intents means separate crimes. Step 3. Consider complex crimes. If your analysis points to a single act resulting in 2 or more grave or less grave felonies, you're likely dealing with a complex crime under Article 48. Examples again. Firing that single shot that kills 2 people, or the single acts of rape that also causes serious physical injuries. Remember the formula: one action, multiple immediate serious outcomes. Step 4. Assess the applicability of the doctrine of absorption. Does this situation involve lesser offenses being committed as a necessary means for committing a principal graver offense? If so, the lesser offenses might be absorbed. The classic: using a falsified document, lesser, to commit estafa, graver. Falsification is absorbed because it was the necessary means. Absorption also applies if a single criminal act results in multiple injuries, but some are inherent to the main crime. For example, slight physical injuries inflicted during a rape might be absorbed by the rape charge itself, as the use of force causing such minor injuries is often seen as inherent in the commission of rape. Step 5. Determine if the offenses are continuing crimes. Is the situation characterized by an ongoing unlawful act or series of acts spurred by a single impulse, stretching over time without real interruption? Like rebellion, or perhaps systematically sending multiple threatening letters over an extended period for extortion, which could arguably be seen as continuing or continued, depending on specifics. This distinction matters especially for the statute of limitations. Step 6. Examine if special complex crimes apply. Does the specific combination of acts fall into one of the predefined categories in the revised penal code, like robbery with homicide, kidnapping with serious physical injuries, or rape with homicide? If yes, the law prescribes a single specific penalty for that exact combination. Here, intent still matters, but in a specific way. If the primary intent was clearly to rob, and killing was just incidental or to eliminate an obstacle during the robbery, it's robbery with homicide. But if the primary intent was actually to kill someone and robbing them was just an afterthought, they might be treated as separate crimes, homicide and theft robbery, not the special complex crime. Step 7. Check if offenses fall under special laws. Finally, always be aware that certain offenses are defined and penalized under specific special laws, separate from the main revised penal code. In these cases, the general rules governing complex crimes under Article 48 might not apply, or might apply differently. It's absolutely essential to consult the specific law in question to determine how multiple offenses under that law are treated. Always know your sources of law.
What a deep dive. Seriously, we've navigated some really intricate waters today looking at the plurality of crimes. We went from the single act, single intent ripples of formal plurality all the way to the distinct, separate currents of material plurality. We've seen how the doctrine of absorption acts to simplify things, how complex crimes bundle related offenses, and how continued and continuing crimes stretch criminal liability across time.
It really does show how our legal systems work incredibly hard to try and fairly classify criminal behavior. It's a constant balancing act, isn't it? Trying to balance the strict letter of the law with the nuances of underlying intent and the actual harm caused. These careful distinctions we've talked about between a single impulse and multiple criminal designs, they are absolutely essential for achieving proportional justice, making the punishment fit the crime, not just in severity, but in its structure. It does raise an important question, though, doesn't it? How does society, through its laws, best weigh the sequence of actions versus the totality of the consequences when deciding culpability? It's a deep philosophical challenge embedded in these legal rules.
Absolutely. And understanding these nuances, these different categories and doctrines, it isn't just for legal professionals, is it? It's really for anyone who wants to grasp the sophisticated, sometimes complex machinery of justice. So the next time you hear about a crime or maybe a series of crimes in the news or anywhere else, hopefully you'll have a much deeper understanding of the thought process, the legal framework behind how those actions might actually be classified, prosecuted, and ultimately penalized. Thank you so much for joining us on this deep dive today. Keep questioning, keep learning, and we'll catch you next time.